SJC-09656, Commonwealth versus Caruso.
Mr. Lewis, good morning.
May it please the court, good morning. My name is David Lewis. I represent the defendant in this matter, Mr. Caruso. I'd like to start off this morning by talking about Mr. Dubas, the informant at large that testified in Mr. Caruso's case. As I point out in the briefs, there's plenty of factual information in the record that Mr. Dubas was an informant at large, the type of informant at large, actually, that Murphy identified as the real villainy in the system.
Before you get there, I couldn't see what exactly Dubas said the defendant told him. Was that in the briefs in terms of the content of the admissions that he testified to?
I don't believe, I think I referenced the...
Yeah, what did he say? I mean, I don't know what Dubas said the defendant told him.
My recollection, I think I put the page references in there. It was more a length of the brief issue than anything.
But just
Substantively, what was
what's
it?
the gist of what he said?
Wasn't supposed to die, glad she's gone, something of that nature, you know, certainly inculpatory.
Okay.
As I point out, you know, Mr. Dubas has his contact, Sergeant Plath, who he refers to as Jim. He has a previous record as an informant. He has a previous record of benefits received. He knows what the Commonwealth wants to hear. He testified to that. He knows what it'll get him. It wouldn't matter if he was a little kid or a grown man. He knows he has a service, he provides it, he gets a benefit. I would argue that Murphy, as I was saying, addressed one part of the problem of the system with the agency relationship, that directing someone to a particular defendant, and sort of removed that from the equation. But somebody like Dubas, I think Murphy sort of underdrew the circle, if you will.
Was there an agreement with the government?
Sure, by his course of performance, absolutely.
But
He knew.
Was there an agreement? I'm not asking you if you could infer an agreement. I'm
Okay.
asking you about the applicability of Murphy. Was there an agreement with the Commonwealth?
No, there's no articulated agreement. And that's the difficulty with Murphy. I mean, the more formal you're going to make that requirement, the easier it is more easily it is to circumvent. They all know that. They all know not to say, hey, if you get us some information, we'll make sure you stay out of state prison.
But this is, unlike some other cases, there's absolutely no, is there any evidence of any conversation between Plath and Dubas before any of this?
Sure, in all the other cases, he's provided
But I mean
information.
in relation to this case, or this guy.
No, and Plath is his contact. He knows, he gets it, he makes up his story or gets his information, however you want to describe it, and he gets on the phone, he calls Plath, and Plath comes to visit him. He gives it, Plath said, you know, doesn't promise anything because he knows he can't under Murphy or Reynolds. He knows that's not allowed. He says, I'll refer you to the prosecutors and we'll see how it goes. But Dubas knows, because it's happened before and his record is so voluminous, there's no other explanation for that.
Does this require us to extend Fritz and Murphy to make your point?
I think it requires everyone, or this is, personally, this is the ugliest evidence in the system. And this isn't some sort of fragile, sort of nice thing that really needs to be kept around. The professional informants need to be removed. They're there, they know how to do their job, they read the papers, they talk to other people, they know what the Commonwealth wants to hear, they have a course of performance.
The answer is that Murphy and Fritz should be extended.
Correct.
And you believe that Judge Gerbeau got it right under existing law?
No, I mean, I think he should have been left out. I mean, this was so egregious.
But applying the present law, as
Yeah.
Judge Gerbeau did and made those findings, do you concede that he got it right and you want us to change the law? I asked you a
I mean,
two-part question. You could ask him-
Murphy was definitely after. I'm blanking on when Reynolds was decided, but so I can't say for certain. But yeah, I mean, I'm saying that. I mean, the whole problem, right, is this doing indirectly what they can't do directly. and getting this information in a way that they can't otherwise get it and circumventing the Sixth Amendment right to counsel, right? That's what this is. That's the core of this problem. And
Judge Corbeau found no explicit promise, right, and no violation.
right, and I can see that. There is no explicit promise because they know they can't. But that doesn't stop it. And that this, Dubas is a perfect example of how and why.
But aren't you conflating two quite separate things? I mean, there's the one concern that the government is going to interfere with the Sixth Amendment right to counsel by in some fashion causing somebody to have a conversation with a defendant awaiting trial that they could not do directly, and using a fellow inmate as an agent to do that. That's one concern. And the second concern is your view that these types of roving informants seeking to help themselves at every opportunity are so unreliable that we should say that they should not be allowed to testify. It's an unreliability test, sort of analogous to the unreliability of an eyewitness ID. Are you basing this purely on the Sixth Amendment, or are you basing this on the inherent unreliability of this type of testimony?
No, I mean, I think I would disagree with you a little bit. I think there is, this category of evidence certainly is extremely unreliable and leads to, some studies show, leading cause of false convictions. But I think just because there's no direction to particular, hey, we'll put that guy in the same cell together, just because that's not happening, and just because someone is an informant at large, that does not mean it's not a Sixth Amendment.
But where is the governmental misconduct? I mean, if
could-
some private person speaks to somebody awaiting trial, and the government has nothing to do with it, it's not a Sixth Amendment issue. It's only when the government in some fashion is doing that it becomes a Sixth Amendment issue. So where is the government misconduct under your scenario?
The benefit.
I'm sorry?
The benefit. Dubas isn't doing this just to be a good citizen. Dubas is doing this to get a benefit. He wants to stay out of state prison. He wants to stay on the Vineyard or down on the Cape in Barnstable House of Correction. So, and he knows to do that. He has a serious record. It's extremely lengthy, very serious. He knows from past experience and getting rewards for the information he's provided that the way to do that is to give them information.
Why isn't that a closing argument? We put our faith and our fate in the jury.
This stuff, I mean, it's the leading cause. I think this is a predicate to that. I don't think you can default the Sixth Amendment or Article 12 and say, well, just let's let the jury sort it out. I think this stuff is so prejudicial and so ugly, really, and so egregious when it's wrong, and so susceptible to corruption and fabrication. I mean, there's a reference in the brief, I think the famous case in Los Angeles County is Leslie Vernon White, and they have all these articles talking about this. In LA County, this one snitch was responsible for a number of convictions, and he talked about how he did it. He said, oh yeah, I just clipped papers and had a little file system, and I'd see some guy and I'd go to my little file and I'd read up on his case, and there I go. And then I'd give a call to my contact, and I was in business.
I gather there's no evidence that the government was involved in arranging for Dubas to be with the defendant when he went to Shattuck Hospital.
No.
So this was not an arranged rendezvous.
There's no evidence to support that, no.
And is there any, I mean, this goes to Chief Justice Gantz's question, but I take it if you've got a career informant, the question of whether the Sixth Amendment has attached to the person whom he's choosing to inform about, seems to me that's certainly not always a given. I mean, it wouldn't have to be, right? You could have a pretrial, you could have somebody who's just held. In other words, it goes to this government involvement question. Because at least as I hear what you're saying, Dubas figures out, oh, this is a ripe one. I'm just going to go after this. But whether or where it is in the council, appointment selection process seems a secondary matter. Or am I wrong about that?
No, I mean, the council would have to be appointed obviously to trigger it. You know,
That's not what's motivating Dubas, is from your perspective, right?
What do you mean? I'm not following, I'm sorry.
Well, I guess what I'm saying is, we're looking at Dubas doing these things, but the question is, what's the government involvement? And the government involvement, at least under the Sixth Amendment, doesn't happen until the person has been arraigned and so forth. So, but Dubas is his roving ambassador, regardless of where or when that's happening. So there just seems to be a disconnect. It goes more to the that's why I think it goes more to the reliability than it does to a Sixth Amendment violation.
You know, I think Dubas, I don't think he knows what the coin of the realm is, right? This is a government marketplace because defendants aren't involved in this. This is them. They set it up. They set the price. They set the benefit, the reward, everything. It's their marketplace. They're monopolists, basically. And I don't believe Dubas knows it. Whoever he comes across through his, travels through the system, I don't think this is I think he's pinging Plath on a fairly regular basis. I mean, he calls the guy Jim. The guy's this mass trooper. He knows him on a first-name basis and has his phone number. And I don't think, if he calls somebody up, I would imagine, and no counsel was attached, maybe they would deal with it differently. I don't know. But in this case, he did have counsel, and I think it is a Sixth Amendment and Article 12 violation.
If I can turn you to the reload confrontation issue, the testimony.
Oh,
that
John
came in
Busa,
through
yes.
Busa. Again, I could not precisely tell what you claim that Busa essentially was simply reporting what he had no personal knowledge of, but knew only because of, I believe it was Arnold. But I couldn't tell precisely what you say came in that should not have come in under Barboza and the various case law we have,
Right.
which I guess all of which happened after this trial.
Right. So it's reversed. It's Busa was part of the seizure at the defendant's house, seized the evidence, emptied them out, analyzed them. He did all of that.
Busa or Arnold?
Busa.
Okay.
Busa did that. During trial, he writes a report about his findings that he believes the reload, or so forth and so on. He gets sick. I'm not contesting his absence. Arnold comes on to testify as to the report, and not independent findings. He testifies to Busa's report, and that raises the issue, obviously, of.
Okay, and what specifically, I mean, let us assume we find that to be error, okay? Then the next issue is harmless, whether it's harmless or not, because I gather it was objected to. What do you say came in that was so substantive that it would not constitute harmless error?
The Commonwealth spent a great deal of time during the trial trying to connect substances found at the defendant's house with the accelerant that was in the pipe bomb. And they brought in, dog sniff, the dog detection unit on 2 different occasions, and both times it was completely negative. They examined the reload was their connection in that sort of chain of circumstantial evidence connecting Mr. Caruso to that substance, to what was in the pipe bomb. Busa is important because he is obviously critically important. He was the person that identified it as reload, and he was the person that testified as to its likelihood of being that evidence.
Didn't Arnold testify that he examined this ammunition and he believed personally that these are reloads and talked about what a reload is?
My recollection is that's his report. He didn't testify because he was sick.
No.
Oh, no, Arnold.
Arnold.
Didn't he reinvestigate? Didn't he look at it himself?
I think he looked at the bag. I don't think he didn't retest it.
But Busa is in essence a chain of custody. I know he did an examination. He testifies in essence as chain of custody. Arnold takes a look at the ammunition, says these are reloads and these are what reloads are. He's testifying about his personal knowledge, right?
Yeah, but he didn't really, yeah, but he doesn't retest anything. He just looks at the bag. He didn't actually test it. He's just testifying to what's in the report.
No, I thought he did test it himself.
Oh, on Busa, my recollection is that, I may be wrong, I mean, it's a large record, but Busa, my recollection is that Busa was the only one that did that analysis of it before giving it to the state chemist, Mr. Drugan.
And Drugan testified
And Drugan
well.
testified, correct.
personally.
Right. And the far as he could get with the reload material was consistent with. He couldn't, it was not a match. And I'm saying that with the ability to cross-examine the guy who's actually making that determination, yeah, this is it. And I think the ATF agent who testified had said,
The point was that these are reloads, and this is the manner in which someone does a reload. They have to put gunpowder, and that leads to the inference that your client had gunpowder, right?
that's part of it. My recollection of it, and again, I may be not remembering this correctly, but my recollection of it was that was certainly part of it, the technical aspects of it, but then there was a substantive aspect of it that was the link between, linked it up to Drugan, who then linked it up to the crime scene.
Was this part of the 13 bags?
I
Is that
believe so, yeah.
which Busa collected, right?
Correct, yeah, that's right, yes.
And, but at the end of the day, isn't what matters what Drugan says about it? That is what it is?
Well, that goes back to that goes back to my previous comment. I think certainly it matters what Drugan says, but I believe what Busa had to say, while partially the technical aspects, sort of chain of custody, there's a category of what he was going to say from his report that's substantive. Like, this is what I did, and this is why I think it's this, and this is why I think it's what it is.
Let's separate these personal knowledge issues, chain of custody issues, from basis of expert testimony issues, and whether or not one expert is just saying what another expert's view is, or whether he independently reviewed the material and then came up with his own opinion, because it's all mushed up together in this argument. So number one, are you saying that there's no basis for the expert testimony because we've got no personal knowledge, no one's testifying the chain of custody, so you can never get to the point where an expert can give an opinion about it without having Busa there?
Strict chain of custody? No.
Okay, so that means that the expert testimony, they at least can look at this material, and if they do come up with their own opinion, that it's not just a conduit for another expert, but it's an independent expert opinion.
Drugan or Arnold?
I'm asking you.
I'm saying that Drugan alone, while significant, is not the entirety of that evidence.
So you're saying that Arnold rendered an opinion that it was reload? Yes?
Correct, yes.
And you're also saying, and this is where I thought he had, you're saying that all he was doing in rendering that opinion was repeating Busa's opinion? Is that what you're saying?
Yes, in the sense he didn't redo any of the analysis. He looked at Busa's report, he looked at the bags, he said,
But can't you look at a cartridge and say, this is a reload, just
"Oh,
visually?
that isn't what Busa did. Busa did more than that.
I'm not asking you that.
Yeah.
I'm asking you, couldn't Arnold, in his many years as a ballistician, look at a cartridge and say, in my opinion, this is a reload?
That's not my recollection of how it played out. It wasn't that simple. If it was, I probably wouldn't have raised it, to be honest with you. But
But you don't remember?
I don't remember exactly. My recollection is his testimony was a little more involved than that.
Okay.
It wasn't necessarily he just looking at it and saying, I can tell by looking it's reload, because Busa did all the testing and to nail it down a lot more concretely or reliably, rather than simply just looking at something and saying what it was. I've only got about 40 seconds left or so. I'll just wrap up by pointing out, I believe the evidence about the seizure of the evidence by Aftermath, the private company that was used after the killing, I believe it is testimonial hearsay. I think the the passages in the Clausel-Jones case talk about, people getting on the stand who are saying, I don't know, and you can't establish the substantive nature of that, point to that. And as when the one testified, he didn't even know that Aftermath had brought them over. Someone had told him that. I'll rest on the brief.
Okay, well, I think there's one more question from Justice Lowy.
You have a whole part of your brief that deals with 804B1 not being satisfied as it relates to the former testimony exception, don't you?
That's correct,
It
yeah.
raises an evidentiary issue and a confrontation clause issue.
That's correct.
Okay, all right. I'll ask the prosecutor about it. Thank you.
Okay, thank you. Ms. Langsam, good morning.
Good morning, Your Honor. May it please the court, my name is Jessica Langsam. I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. With me is Assistant District Attorney Elizabeth Dunnigan, who's also from Middlesex and who is one of the trial attorneys in this matter. I'd like to begin just with the court's questions regarding Trooper Arnold and Captain Busa. Captain Busa performed no testing. What Captain Busa did was he took some of the ammunition that had been seized from the closet in the defendant's room pursuant to the first search warrant, took 13 different calibers, types of ammunition, emptied them into clear plastic bags, and those were the 13 bags that were then entered into evidence through Trooper Arnold. There were no tests conducted. The only individual who conducted tests on the ammunition was Chemist Drugan at the Mass State Police Crime Lab.
So there was no evidence from anybody. Who testified, if anybody, about reload?
Trooper Arnold testified about reload, and he testified based on his 27 years of experience working in the state police with firearms in the firearms identification section. He worked under Captain Busa. He was not present at the time of the search, and as elicited on
Was that looking at these exhibits and saying, in my opinion, it's reload?
Yes, Your Honor. He actually examined the ammunition prior to trial, and his testimony was that he looked at it, I believe it was exhibit number 102, and that's from the trial transcript on August 6th of 2003. And he acknowledged that he didn't know what Captain Busa did apart from reading the report, but that he ascertained that some of it was reload, and he knew that based on his experience that simply more ammunition had been put into a used cartridge. So that was Trooper Arnold's testimony, and it really just went to the chain of custody because Chemist Drugan testified that he received 13 bags of ammunition from Captain Busa.
Okay, so slow down because I'm not the world's leading expert on reload. So Busa puts the ammunition into the bags, or he pulls out the ammunition to let the gunpowder in the bag.
I'm not sure if there's a distinction there, Your Honor, but Captain Busa...
He just threw the bullets in the bag, or did he open the bullets?
He emptied out the ammunition into the bag. So these are clear plastic bags.
You say he emptied it out. I mean, he undid the bullets to let the gunpowder go into the bag.
Yes, Your Honor. The only thing contained in the clear plastic bags is gunpowder.
Okay, so he already had taken the bullet apart in order to let the gunpowder go into the bag.
Yes.
Okay, so what was in the bag was purely gunpowder.
Yes.
And how then does Arnold look at the gunpowder in the bag and say, aha, that was reload, as opposed to gunpowder that was in the bullets when they were purchased over the counter?
Yes, Your Honor. Trooper Arnold testified that he examined, I believe it was exhibits 99 through 102 prior to the trial. These were boxes of ammunition that were seized from the closet in the defendant's bedroom pursuant to the first search warrant. In examining that ammunition, he testified specifically regarding Exhibit 102, that it was a plastic ammunition box containing live .380 automatic ammunition, some of which appears to be reloaded, others appear to be factory. He made that determination based on his extensive experience with firearms that, yes, Your Honor?
When he said that, was he testifying about the contents of a plastic bag, or I thought you just said a box? So that wasn't talking about the bags.
That's correct, Judge. He was not talking about the bags. Okay. There were 4 boxes of ammunition that had been entered into evidence through Trooper Burke, who had searched the closet along with Captain Busa in executing the first search warrant. The ammunition was seized, and 4 boxes of ammunition were admitted through Trooper Burke in his testimony as part of what had been seized. It was some of this ammunition that Captain Busa had taken the cartridges from, emptied them into the 13 bags. It was also these 4 boxes of ammunition that Trooper Arnold had examined prior to trial and determined that some was reload.
So these were ammunition that hadn't been emptied into the bag, is that right?
That's correct, Judge. These were bullets in plastic boxes, and they were labeled. So that came into evidence.
So he testified that he made that determination based on his observation of Exhibit 102 or based on his review of the report by Busa?
Based on his observation of Exhibit 102, and that's at page 52 of that August 2nd
And did he
transcript.
explain, I've not looked at the testimony, of course, did he explain how you can ascertain whether it's reload by looking at the bullet?
Yes, Your Honor, he did. He explained that manufacturers have a stamp that you can tell, I think, and a lot of this was elicited on cross-examination from the manner in which the jacket and the base of the manner in which the bullet is sort of refigured, that it might appear different, that it could appear to be worn. And I think the defense had even asked if there was some corrosion, and Trooper Arnold said, no, I didn't see any corrosion, but it did appear to be more worn. That's the way he could tell that it had previously been used to fire and then was being reused and reloaded with gunpowder. If I could address the issue regarding Mr. Dubas, and Mr. Dubas's statements to the defendant. That's set out the Commonwealth's brief at page 48, Your Honor, and specifically what Mr. Dubas, what the defendant told Mr. Dubas when they were in the cell at Shattuck Hospital on June 14th of 2002 was how the defendant made the bomb. Specifically, Dubas said that the defendant had a friend, Jeff, who knew about bombs. That the defendant got the bomb to the girl's house. It would kill anyone who opened it and would only go off when someone opened it because of a, quote, basic separation device, unquote, and that he put the victim's sister's return address on the box. He didn't refer to the victim by name, but he called her a derogatory name, and that when he talked about her, he became agitated. He kept his hands clenched. He said he used ever-ready batteries in the bomb, that the evidence that they, I guess meaning the Commonwealth, had against him was a piece of pipe and some batteries, which the defendant said did not match, and that he had purchased the batteries someplace else. He also said that the victim had treated him, quote, like crap and would not go out with him, that she had a videotape of him messing with her car, and that you couldn't tell it was him in the video because the person looks taller. That was the essence of what the defendant testified.
And was there evidence as to whether any of that had been in the public domain before he reported this?
I beg your pardon, Your Honor?
Was there evidence as to whether that information had been out in the press before he told this to Platt?
There was no evidence that that information had been released. In fact, and I'm trying to remember the motion testimony as well, I don't believe that there was any testimony about that. And I don't think that specific details of the crime had been released. So I think that was the point, is that Dubas had related information that had not been released.
The car and the pipe bomb, the car, that had been out there, hadn't it?
You mean that the defendant had previously vandalized the victim's
Yes,
car?
yes.
Yes, Your Honor. That was the trial from May of 1999.
Right,
in
but the
Malden
rest
District
of it,
Court.
you're saying you don't think was, the stuff that really related to this crime?
To the bombing, that's correct, Your Honor. I wondered if the court, if I could address the issue regarding the videotape. And the defense had sought to admit the videotapes. These were the 2 videotapes from what Your Honor just mentioned. The 1999 Malden District Court case where the defendant was convicted of 2 counts of malicious destruction of property for pouring battery acid into the victim's car's gas tank. And the defense sought to admit these 2 videotapes to show that the victim was mistaken in her identification. Justice Gerbeau denied the defense motion to admit the videotapes and also to admit expert evidence pertaining to the videotapes, which the defendant had argued purportedly showed that the person who committed that crime was approximately 6 feet tall. The defendant is approximately 5 feet 6.5 inches tall. So the defense was trying to attack the victim's credibility by using this videotape. Justice Gerbeau denied the motion and pointed out that at that trial, the victim had testified. The videotapes never showed the face of the individual who committed the crime. In fact, the defense, in a written opposition, had argued that the tapes were dark and murky and that the person's face wasn't able to be seen. The victim had testified that she saw the defendant's face in that second incident of the October 25th incident. She was lying on her couch watching television. She also had a VCR directly to a television set up next to her television. She saw an individual walk up to her car. She immediately called 911, and she ran downstairs, and she looked through the window in the door, and that's the door on the right in Commonwealth Supplemental Record Appendix, page 1. And through that window in the door is when the individual passed under the streetlight, she saw the defendant's face. And when she called 911, twice she said, "It's Stephen Caruso, it's Stephen Caruso, he's wearing all black." So I'd submit that that evidence was properly excluded. There was never any showing that was ever connected to the murder.
The Commonwealth had sought to put the video in the murder case, correct?
Yes, Your Honor. The Commonwealth had initially sought to admit the video along with other materials to show the defendant's bad acts, to show the hostile kind of actions that the defendant had taken against the victim. The Commonwealth subsequently narrowed its request, just seeking admission of those two portions of the transcripts, the 58A and 58B hearings.
Okay, so it wasn't a denial by Judge Grabeau as to that evidence. The Commonwealth withdrew the request.
Yes, Your Honor. Well, actually, the judge had denied it, but then the Commonwealth pointed out to Judge Grabeau, actually, we've narrowed our request and we're no longer seeking to admit that. And then the judge permitted the Commonwealth just to admit the two transcript portions, which is all they wanted, not the videotapes. I would.
Can you talk about the former testimony exception? Wasn't testimony of the victim from the malicious destruction of property case admitted at the trial?
Your Honor, no, not from the trial, but from a 58A and 58B hearing that were held in November 98 and April of 1999.
On the malicious destruction of property?
Yes, Your Honor.
And we don't have any case that says the former testimony exception in a criminal case can be from it can be from a different proceeding. It could be from a 58A, like in Hurley, with the same prosecution. But here, you're taking former testimony
Yes.
from a different prosecution and using it at this trial with an unavailable out-of-court declarant, so you've got that satisfied. But we've never had a case that said that you could take, in a criminal case, that you can take another transcripts from another trial and use it as former testimony. Just put aside the Confrontation Clause issue for a minute. This would be the first time we've ever done that, wouldn't it?
I don't believe so, Your Honor, and I can't recall the case I cited in my...
Well, versus Cannon is the case that with Liakos' dissent.
Cannon is the case, I think, Your Honor, where proceedings from a civil case were
Right.
subsequently admitted in the criminal case.
Exactly.
And I know, and I'm sorry I can't recall for the court, that there was a case where a 58A hearing where portions of the transcript were admitted at a subsequent criminal case.
But that was the
Chief
same,
Justice Gantz wrote, I think.
but it was the same case.
Well, I'm even sorry I can't recall the name of the case.
It was Hurley, it was the same case.
Okay.
Okay, so this is completely new, what you're asking us to do under 804B1, is to take a unavailable witness
Yes.
and say that former testimony can be admitted under that exception. You don't have similar motive and opportunity to cross-examine, which is sort of the core of 804B1.
Well, I would disagree with you, Your Honor. You absolutely had the exact same similar motive and opportunity. In fact, the defense had excellent representation all along in the Malden District Court case, in the 58A hearing. In the Malden District Court case, he was represented by Attorney Elliott Levine, but the evidence was introduced for the exact same purpose at that hearing, and that was to show this hostile actions, this nature of the relationship between the parties, and everything that the defendant had done to her up to
But
then.
the craft of advocacy is completely different when you are addressing a 58A hearing in a malicious destruction of property case, as opposed to when you're faced with testimony from the victim who's not there to be cross-examined in a murder case.
Well, Your Honor, two things. Actually, I would disagree with Your Honor. The motive was the same there in that case. The Commonwealth was trying to show that the defendant was dangerous and needed to be held. And after detailing this litany of incidents, which began with the victim turning the defendant down for a date, the defendant smirking, hateful stares, making her life miserable, going to her boss, trying to get her fired, slashing her tires, then pouring battery acid in her car's gas tank. It was all of those incidents. And further, when this testimony came in at the trial, not only did the defense cross-examine the victim's testimony with the cross-examination from those two hearings, but Justice Gerbeau further permitted the defense to further cross-examine the victim's testimony with portions of transcripts from a number of other proceedings.
So in the malicious destruction of property case, the mode of opportunity to cross-examine at the 58A is, and a 58A can be enough to be a former hearing, no doubt about it, not all the time, but sometimes. The motive there was a combination of dangerousness and whether or not this was the person who, in fact, had the malicious destruction of property of the victims. At the murder trial, the purpose is completely different. It's to show a state of mind and hostility. Those are two different things.
Actually, Your Honor, it was really to show the hostile nature of the relationship in both instances. That was the primary purpose of the 58A, and that was, as Justice Gerbeau instructed 3 times in the preliminary instructions prior to the admission of this testimony and in the final charge, that you're going to hear some bad acts or you've heard some bad acts. You're not to judge the defendant based on those. The only charge he's standing trial for is murder.
Okay, so I understand. So we have not one case in Massachusetts where the former testimony exception in a criminal case has allowed the former testimony to be from another proceeding. Are you aware of any federal case whatsoever or any state case on a criminal side where they can be 2 different prosecutions?
Your Honor, as I stand here today, I know that I'm not aware of any other case that hasn't already been mentioned today.
Okay, so this is a significant expansion of 804B1 that you're requesting.
Your Honor, I would disagree with the court just for the reasons that I've already stated.
Well,
I
if you
don't
wish
think
it-
so.
If you wish a 16L letter, if you find those cases, if you'd promptly furnish those to us.
Thank you, Your Honor.
Sticking with that, though, I mean, you say the purpose of it at this trial was to show hostile intent.
Yes.
Pragmatically, that was the inference that you would draw if it indeed was him. I mean, realistically, the issue was that Caruso who was doing that? Then you would argue to the jury that that demonstrates hostile intent. But the factual issue with regard to the prior testimony was it Caruso who indeed was the person who had done that to her car?
Well, that's true just with respect to the incidents involving the car. And the victim's testimony wasn't only that she saw his face on that one occasion. She also recognized him from having waited on him for years and having seen him in Bickford's for years. She recognized him initially when he first slashed her tires by his gait, by the manner in which he was moving away. And she chased him down the street after that second tire slashing.
We have 2 cases in which somebody's walk arguably is identifiable today. Mr. Lewis says the judge did not permit cross-examination with regard to that issue and denied. What did the judge say could not come in to impeach that out-of-court testimony?
Your Honor, I believe that that's pertaining to the videotapes that I had just mentioned.
Right,
Where
right.
the defense was seeking to admit the videotapes to further, actually the defense was arguing that they wanted to show that it wasn't the defendant who committed the crimes. Not to upset the Malden District Court verdict, but as part of their defense under Pettyjohn versus Hall.
And why was that appropriate since the prior testimony was offered as to the issue that it indeed was him who did it and therefore that is demonstrative of hostile intent?
Why was that not appropriate, Your Honor?
Yeah.
It was not appropriate because the videotapes did not show the face of any individual. They didn't impeach the victim's testimony. In fact, they were dark and no face was able to be seen.
Well, so the judge said, I have looked at this and there's no probative value for them, or
Well-
obviously the defendant thought differently.
Well, Your Honor, Justice Gerbeau, and this is on Record Appendix page 951, Justice Gerbeau denied the motion to admit the videotapes and to admit expert testimony regarding the videotapes. As we've learned since then, the videotapes was the subject of a motion for new trial that defense counsel filed in 2008 regarding the Malden District Court convictions. And the evidence proffered in that motion was the exact same evidence that defense counsel submitted in this, at the murder trial. Namely, that was a plot plan, testimony of 2 surveyors, and a CAD, a computer-assisted design video that was taken from a still photograph of the second incident of malicious destruction of property on October 25th of 1998. The Commonwealth responded to that with an affidavit and a report from an FBI supervisory technologist, Richard Vorderbrugge, and the defendant was trying to show that based on their CAD design, the individual who committed this malicious destruction of property was approximately 6 feet tall. The Commonwealth's evidence showed that the individual who committed it was approximately, 5 feet 6.5 inches tall. Justice Flynn, who had presided over the Malden District Court case, concluded that justice was done, denied the Rule 30B motion, ruled that there was no ineffective assistance of counsel, and that the evidence did not show what the defendant claimed that it purported to show. The defendant appealed, and the appeals court said at 85 Mass App Court at page 35, quote, "We can confidently state that the Rampion analysis," and Rampion is the name of the company that did this CAD design, "is not the unshaken documentary proof that the defendant claims." So what the defendant is really seeking now is where this has already been determined that it doesn't show what the defendant claims it shows.
At its core, was Justice Grabeau's ruling a relevance determination?
I beg your pardon, Your Honor?
Did Justice Grabeau make a relevance determination?
I think Justice Grabeau, he did make a relevance determination. He actually based his written ruling, obviously, in 2003. This was prior to 2008. He looked at Pettyjohn versus Hall, and in Pettyjohn, if I could continue, in Pettyjohn, there was a crime. There were 2 witnesses to the crime, the victim and an eyewitness who purportedly knew the defendant. The eyewitness is looking at a photo array, narrows it down to 2 people, and says, "It's absolutely that one." Police officer says, "Try again." So he says, "Okay, it's the other guy." So defense counsel successfully suppresses that due to the police involvement. And then at trial, defense counsel, having successfully suppressed that, wanted to call that individual to show the misidentification. Here was someone who apparently knew the defendant, knew him by his street name, yet picked out another person. So that was testimony of a key fact witness. And Justice Grabeau said, that's not what we have here. We have expert testimony about this video, which is different. It's within the court's discretion to limit this additional expert testimony, or also, there had already been impeachment of the victim, so this would have constituted further impeachment of the victim. Also, Justice Grabeau pointed to subsequent federal law that there needs to be a nexus between this other person. This is under Sikora versus Duggar, which is cited in the court's opinion in my brief. There needs to be a nexus between this other person and the crime, and the defendant had not shown any nexus here. So that was really the basis of Justice Grabeau's ruling.
All right, thank you.
Another question, Chief. Thank you. Only the confrontation clause issue is preserved on the former testimony, is that right?
Only the confrontation.
As it related to the former testimony exception, that was the only issue preserved?
You mean from the earlier trial?
Right. No. At the trial,
Yes,
when the malicious destruction of property transcript came in evidence.
or the 58A and 58B hearings, Your Honor.
Right.
Yes.
That was objected to.
Yes, it was originally objected to.
But it was objected to on constitutional grounds. I'm
No,
pretty sure.
Your Honor, actually, that's not correct. The objection at trial was based on the volume of evidence. That's what the defense was concerned about. So here, this court's looking at whether or not admission of that gave rise to a substantial likelihood of
And
miscarriage of
that's
justice.
where my question is going.
Yes.
How important was that testimony as far as the big picture in this case?
Well, there's no question that the defendant's motivation to commit this crime was important, obviously not an element of the crime, so it was important. But I point out for the court that there were a number of other witnesses who testified to this hostile relationship or the defendant's actions. There were other waitresses from Bickford's who testified. The victim's manager, Alex De La Grata, testified. Mr. Robertson, who was the general manager of several Bickfords, testified. And they all supported this hateful stare, smirking, making her uncomfortable. The other witnesses also testified to the violation of the restraining order when the defendant drove by the Bickfords, after which time his bail was revoked after the April 23rd, 1999 hearing. So there was other evidence presented from other witnesses.
Thank you.
All right, thank you.
Thank you, Your Honor. I would just ask, because there's no basis for new trial or to reduce the verdict, that this court affirm the judgment of conviction of the murder in the first degree of Sandra Burfield.